a business owner's nightmare. The company hires and trains an employee to work in a woman's boutique. And the clients love the employee, but she quits unexpectedly. And then 1 week later, the owner drives by the former employee's new shop, just 1 block from her store, and watches as her clients go there instead of into her store. So how do you protect your business from this heartache? You might need a non-competition agreement. An employee owes his employer a duty of loyalty, but that duty ends when she quits or is fired. And without a non-competition agreement in place, with a few exceptions, your former employee may take your clients and even open a competing business a block away after she quits. So when's a non-competition agreement valid? When allowed, these restrictions must fit your business. Permissible restrictions are based on the prohibited activities and the geographic and time limits. So our boutique owner probably can't prevent its former employee from working in the entire fashion industry, but only a woman's boutique. And a 5-year restriction would likely be unenforceable since the client acquisition cycle isn't that long. If the store's clients come from a 10-mile radius, a statewide restriction is unlikely to be enforceable. Most states disfavor these agreements, which means if your restrictions are too broad, you might end up with no protection at all. So a form non-competition provision is unlikely to be worth the paper it's written on because those restrictions aren't narrowly tailored to meet your business's needs. Non-competition agreements can be a great tool to protect your business. But remember, you want a custom fit and not an off-the-rack agreement. Subscribe to get my latest tips and find more information on my website. I'm attorney Nancy Greene, and I'm here to help you avoid the legal landmines that can blow up your business. Just when you thought I was finished, here's the legal mumbo jumbo.